Everyone, thank you so much for coming to class tonight. Tonight we are going to be discussing part 3 of the residential purchase contract. In part 1 and part 2, we have covered the cover page, and then we covered through section 5 of the residential purchase contract. So tonight we're going to pick up on part 6, which is due diligence. As I've mentioned in previous classes, I know that it's a little redundant that we're going to be reading everything line by line. However, it is extremely important that we all understand what the contract states so that we know the timelines and we can better assist our clients in understanding the contract itself, because many clients do ask us to review it with them. So that is why we do what we're doing tonight. So let's go ahead and get started, because tonight we do have to try to wrap this up so that it's only part 3. So that it's only 3 parts of the residential purchase contract. Inspection period. Buyer's inspection period shall be 10 days or otherwise stated days after contract acceptance. During the inspection period, buyer at buyer's expense shall conduct all desired physical, environmental, and other types of inspections and investigations to determine the value and condition of the premises, make inquiries and consult government agencies, lenders, insurance agents, architects, and other appropriate persons and entities concerning the suitability of the premises and the surrounding area, investigate applicable building, zoning, fire, health, and safety codes to determine any potential hazards, violations, or defects in the premises, and verify any material multiple listing service, which is otherwise known as the MLS information. If the presence of any sex offenders in the vicinity or the occurrence of a disease, natural death, suicide, homicide, or other crime on or in the vicinity of a material matter to buyer, it must be investigated to buyer during the inspection period. The buyer shall keep the premises free of and clear of liens, shall indemnify and hold seller harmless in all liability, claims, demands, damages, and costs, and shall repair all damages arising. Oops, sorry, I lost my spot. And shall repair any damages arising from the inspections. Buyer shall provide seller and broker upon receipt at no cost, copies of all inspection reports concerning the premises obtained by buyer. Buyer is advised to consult the Arizona Department of Real Estate Buyer Advisory to assist in buyer's due diligence, inspections, and investigations. So going back up to 213, the contract is always going to default to an inspection period of 10 days. If you want to make your offer stronger, you can reduce your inspection days to however many days the buyer is okay with. For example, if you know that your inspector can get in there in the next day after contract acceptance, and you want to hopefully win the contract or get your contract accepted is what I mean, then shortening your inspection period to maybe 3 days may be applicable. Another thing that you can do is you can extend it. So a lot of VAs take a little bit longer because sometimes it takes longer to get a VA inspector. Maybe they want to have the VA appraisal come back within the inspection period. I don't know why someone would need that, but they could, because there's definitely the finance contingency if they're worried about it not appraising. But they could extend it. So that's another area. This is where you would do that. You could extend it or you can shorten your inspection period. Square footage. Buyer is aware that any reference to the square footage of the premises, both the real property, land, and improvements thereon, is approximate. If square footage is a material matter to the buyer, it must be investigated during the inspection period. Again, if this is important to your buyer, just make sure that you are, either having the appraiser do it, or having, I don't know if most home inspectors will do it, but some could. Or you could have the buyer investigate if that's important to them. But it does have to be done during the inspection period. If you get into further down the contract outside of your inspection period and it comes up that the square footage, maybe it's because the appraisal comes in and it says, this home is only 900 square feet where the listing said it was 1100. The buyer can back out, because if it was not stated or disclosed in the beginning what the actual square footage is, and then discrepancy could be because maybe a room was not permitted and the appraiser is not going to count it, well, the buyer can actually back out and they can get their earnest deposit back. So just make sure that, again, if it's important to your buyer, it's done during the inspection period. And if you're representing the seller, make sure the square footage is accurate. Again, it is up to the buyer, though, to make sure if it is important to them. A seller, however, should be giving in good faith the correct information. Section 6C. 6C, wood destroying organism or insect inspection. If current or past wood destroying organisms or insects such as termites are material matter to the buyer, these issues must be investigated during the inspection period. Buyer shall order and pay for all wood destroying organism or insect inspections performed during the inspection period. If the lender requires an updated wood destroying organism or insect inspection report prior to close of escrow, it will be performed at the buyer's expense. Usually this is completed when the home inspection is done. Flood insurance. Flood hazard designations or the cost of flood hazard insurance shall be determined by buyer during the inspection period. If the premises is situated in an area defined as having any special flood hazards by any governmental entity, the lender may require the purchase of flood hazard insurance. Special flood hazards may also affect the ability to encumber or improve the premises. Insurance. If homeowner's insurance is a material matter to the buyer shall apply for and obtain written confirmation of the availability and cost of homeowner's insurance for the premises from buyer's insurance company during the inspection period. Buyer understands that any homeowner's fire, casualty, flood, or other insurance desired by buyer or required by lender shall be in place at close of escrow. Just note that if somebody's getting a loan, more than likely they're going to have insurance. And if they don't have insurance, then the lender can go ahead and set them up with with a company, but it is more than likely going to be way more expensive if they were just going to obtain it on their own through an outside company. Sometimes if you bundle car, auto, and home, car, auto, and something else, sorry, whatever it might be, you can get a discount. So it definitely is beneficial for the homeowner to research it and have it set up prior to close of escrow. And they cannot let it lapse. If a lender finds out, or whoever owns the loan, if they find out, again, they will go ahead and implement an insurance, and it will cost the buyer or homeowner way more money. Sewer on-site wastewater treatment system. The premises is connected to a sewer system, conventional septic system, or an alternative system. In the White Mountains or up in the mountains, you might see alternative systems, but typically down here in the valley, you're going to see either a sewer system or a septic system. Note that most county islands are usually on a septic system or have been connected or will be connected to a sewer system. So just make sure you're asking those questions. Make sure you're reading the seller disclosures to see what kind of sewer system it is set up to. And you should also note that if it's currently on a septic system, but it's slated to be connected to the city system, city services, that is a cost that the homeowner will incur, and it can be tens of thousands of dollars. So definitely have that conversation with the current seller to see if there's any plans if it is connected to a septic system. If a seller connection is material matter to the buyer, it must be investigated during the inspection period. If the premises is served by a conventional septic or alternative system, the AAR on-site wastewater treatment facility addendum is incorporated herein by reference. Let's see. It is also up to the seller to have the sewer system inspected prior to close of escrow, and it is 6 months prior, no more than 6 months prior to close of escrow. So just keep that in mind. That is stated on the actual AAR on-site wastewater treatment facility addendum, which we will cover later. Swimming pool barrier regulations. During the inspection period, the buyer agrees to investigate all applicable state, county, and municipal swimming pool barrier regulations and agrees to comply with and pay all costs of compliance with said regulations prior to occupying the premises, unless otherwise agreed in writing. If the premises contains a swimming pool, Buyer acknowledges receipt of the Arizona Department of Health Services approved private pool safety notice. Buyer acknowledgement. Buyer recognizes, acknowledges, and agrees that brokers are not qualified nor licensed to conduct due diligence with respect to the premises or the surrounding area. Buyer is instructed to consult with qualified licensed professionals to assist in buyer's due diligence efforts. Because conducting due diligence with respect to the premises and the surrounding area is beyond the scope of broker's expertise and licensing, buyer expressly releases and holds harmless brokers from liability for any defects or conditions that could have been discovered by inspection or investigation. The inspection period notice. Prior to expiration of the inspection period, buyer shall deliver to seller a signed notice of any items disapproved. AAR's Buyer's Inspection Notice and Seller's Response Form, otherwise known as the BINSR, BINSR, all caps, is available for this purpose. Buyer shall conduct all desired inspections and investigations prior to delivering such notice to seller, and all inspection periods disapproved shall be provided in a single notice. Note that once you deliver the BINSR to the seller's agent, your inspection period has ended. Your buyer can no longer have anybody come in and do any form of inspections. So once the BINSR has been delivered, there's a couple of different things with the time frame that you have to know as agents. This is very important, so that's why I didn't want to cover it in the last class, because I really wanted to hone in on this section. So the buyer disapproval. If buyer in buyer's sole discretion disapproves of items are as allowed herein, buyer shall deliver to seller the signed notice of these items disapproved and state in the notice that buyer elects to do one of two things. The first option is immediately cancel this contract, in which case, if a buyer's notice specifies disapproval of items as allowed herein, the earnest money shall be released to the buyer. If buyer's notice fails to specify items disapproved as allowed herein, the cancellation will remain in fact, but the buyer has failed to comply with the provision of this contract, and seller may deliver to buyer a cure notice as required by Section 7A. If buyer fails to cure their non-compliance within 3 days after delivery of such notice, the buyer shall be in breach and the seller shall be entitled to the earnest money. If prior to expiration of the cure period, buyer delivers notice specifying the items disapproved as herein, buyer shall be entitled to return the earnest money. So what does this mean? This means a buyer just cannot cancel because of no reason. They have to give the seller a reason, and it has to be a reason to cancel. For example, a buyer cannot just continue to look at homes, put in offers, and then get another one accepted and then just cancel because they found something better. That is not a reason. You have to list on the BINSR a legit reason. For example, the home inspection is done. They found water damage, and the buyer has had issues in the past with mold, so it freaked them out and they want to cancel because they did not approve of the current condition of the home, i.e. the water damage. That's one example. Because it was in the inspection, it's a reason for them to cancel. They gave notice to the seller. This is why I'm not moving forward. Another reason, maybe sex offenders was important to them. Again, they have to do that within their inspection period. They have to do all their investigations within that agreed upon inspection timeframe. So if they did a registered sex offender search, they located like 2 level 2 sex offenders that live right across the street. They don't approve of that. They note that on the BINSR. That is a reason for them to back out. They would get their earnest deposit, but they cannot just for any reason cancel and not give the seller a reason. So that's option 1. Option 2 is they can provide the seller an opportunity to correct and address the items disapproved, in which case the seller shall respond in writing within 5 days, or if you shorten it, you can put that here, days after delivery to seller of buyer's notice of terms disapproved. Seller's failure to respond to buyer in writing within the specified time period shall conclusively be deemed seller's refusal to correct or address any of the items disapproved. If the seller agrees in writing to correct items disapproved, the seller shall correct the items, complete any repairs in a workmanlike manner, and deliver any paid receipts evidencing the corrections and repairs to buyer 3 days, or if you specify other days prior to the close of escrow date, or the seller is unwilling or unable to correct or address any of the items disapproved, buyer may cancel this contract within 5 days after delivery of seller's response or after expiration of the time of seller's response, whichever occurs first. The earnest money shall be released to the buyer. If buyer does not cancel this contract within the 5 days as provided, the buyer shall close escrow without these items that the seller has not agreed in writing to correct or address. So this is very important. You have to understand the timeline. Once you deliver the Benzer, the seller has 5 days to respond. Once they respond, the buyer then has 5 days to respond. Depending on if the seller agrees or doesn't agree, whatever it might be, just make sure you respond accordingly. If the seller agrees to fix everything as you put it on the Benzer, like whatever you asked for, you don't have to respond. But if the seller actually responds to your Benzer, you have to then respond back. So just make sure you do that. And we will cover the Benzer in another class in detail, and we'll go through all those timelines again. Verbal discussions will not extend these time periods. If you need additional time on the Benzer, you can put it in writing, and only a written agreement signed by both parties will extend response times or cancellation rights. Buyer's failure to give notice of disapproval of items or cancellation of this contract within the specified time period shall conclusively be deemed buyer's election to proceed with the transaction without correction of any of these disapproved items. Again, we will go over the Benzer in more detail in another class, but you need to know that section of the contract because it does have a lot of timelines in it. Okay, let's talk about the home warranty plan. The buyer and the seller are advised to investigate the various home warranty plans available for purchase. The parties acknowledge that different home warranty plans have different coverage options, exclusions, limitations, service fees, and most plans exclude pre-existing conditions. So, what exactly is a home warranty? A lot of clients ask exactly what a home warranty is and why do they need it? How does it differ from homeowners insurance? So just kind of a general definition, a home warranty. It's a service contract that covers the repair or replacement cost of major appliances and home systems like plumbing, electrical, HVAC due to normal wear and tear. Essentially, protecting the homeowner from unexpected repair expenses when these items break down. Unlike homeowners insurance, which covers damage to the property itself from events like fire or theft, a home warranty focuses on appliances and system malfunctions caused by typical usage. So you can easily just Google that, but that is basically what a home warranty plan is. So the part of the contract that we need to understand is a home warranty going to be ordered and who's it going to be ordered by, the buyer or the seller? That does have to be indicated. TBD is to be determined, is to be issued by TBD at a cost not to exceed. You can put whatever amount in here depending on if there's a pool, if it has additional items like additional fridges, a soft water system, if that's even covered. Does it have a solar system, if that's even covered? Getting familiar with what different companies, Choice Home Warranty is an affiliated company with ProSmart, so you can look at their plans just to get a better idea of what's covered and also at what levels they offer coverage at. So just understand how much coverage should you be asking based on the home that your client is buying. So you can put that in, you can put a dollar amount in here. And then who's that going to be paid by? Is it going to be paid by the buyer? Is it going to be paid by the seller? Or is it going to be split evenly between buyer and seller? Or some buyers just like to decline it, and it's completely fine. But you do have to make it part of the contract and indicate who's paying what. Walkthrough. Seller grants buyer and buyer's inspector reasonable access to conduct walkthroughs. of the premises for the purpose of satisfying buyer that any corrections or repairs agreed to by seller have been completed, and the premises are in substantially the same condition as the date of contract acceptance. If buyer does not conduct such walkthroughs, buyer releases seller and broker from liability for any defects that could have been discovered. Seller's responsibility regarding inspections and walkthroughs. The seller shall make the premises available for all inspections and walkthroughs upon reasonable notice of by the buyer. Seller shall, at seller's expense, have all utilities on, including any propane, until close of escrow to enable the buyer to conduct these inspections and walkthroughs. IRS and FIRPTA reporting. This is a foreign investor. The Foreign Investment in Real Property Tax Act, otherwise known as FIRPTA, provides that if a seller is a foreign person, a buyer of residential real property must withhold federal income taxes up to 15% of the purchase price, unless an exception applies. If FIRPTA is applicable and the buyer fails to withhold, buyer may be held liable for the tax. Buyer agrees to perform any acts reasonable or necessary to comply with FIRPTA and the IRS reporting requirements, and buyer is responsible for obtaining independent legal and tax advice. If you've never done a FIRPTA deal, just make sure that you have a title company that has done them in the past. Snap Title, who's our affiliated title company, they have done a lot of FIRPTA deals, so they're very well versed on how to do them. And then ask them what the not an attorney, so just make sure you ask somebody exactly what the exceptions are on a FIRPTA deal. And in the listing, it'll say FIRPTA may apply if they are a foreign investor, or you can also check the seller disclosures. They have to mark if they're a foreign investor. Cure period. A party shall have an opportunity to cure a potential breach of this contract. If a party fails to comply with any provision of this contract, the other party shall deliver a notice of the non-complying party specifying the non-compliance. If the non-compliance is not cured within 3 days after delivery of such notice, cure period, the failure to comply shall become a breach of contract. If escrow company or recorder's office is closed on the last day of the cure period, the close of escrow must occur to cure a potential breach. Close of escrow shall occur on the next day that both are open for business. So if somebody's in breach of contract, the non-breaching party may cancel this contract or proceed against the breaching party in any claim or remedy that the non-breaching party may have in law or equity, subject to the alternative dispute resolutions obligations set forth herein. In the case of seller, because it would be difficult to fix actual damage in the event of a buyer's breach, the earnest money may be deemed a reasonable estimate of damages, and the seller shall, at seller's opinion, accept the earnest money as seller's sole right of damages. And in the event of a buyer's breach arising from buyer's failure to deliver the notice acquired by Section 2B, or buyer's inability to obtain loan approval due to the waiver of the appraisal contingency pursuant to Section 2I, seller, I think that's Section 2I, might be Section 12, but I think it's 2I. Seller shall exercise this option and accept the earnest money as seller's sole right of damages. An unfulfilled contingency is not a breach of contract. The parties expressly agree that the failure of any party to comply with the terms and conditions of Section 1D to allow close of escrow to occur on the close of escrow date, if not cured after a cure notice is delivered pursuant to Section 7A, will constitute a material breach of this contract, rendering the contract subject to cancellation. So alternative dispute resolution, the buyer and the seller agree to mediate any dispute or claim arising out of or relating to this contract in accordance with the realtor's dispute resolution system, or as otherwise agreed. All mediation costs shall be paid equally to the parties. In the event that mediation does not resolve all disputes or claims, the unresolved disputes or claims shall be submitted for binding arbitration. In such event, the parties shall agree upon an arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to the American Arbitration Association in accordance with the AAA arbitration rules for the real estate industry. The decision of the arbitrator shall be final and non-appealable. Judgment on the award rendered by the arbitrator may be entered into any court of competent jurisdiction. Notwithstanding and foregoing, either party may opt out of binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event, either party shall have the right to resort to court action. Exclusions from the ADR. The following matters are excluded from the requirement of ADR hereunder. Any action brought in the Small Claims Division of the Arizona Court up to 3,500, so long as the matter is not thereafter transferred or removed from the Small Claims Division. Judicial or non-judicial foreclosure or other action or proceedings to enforce a deed of trust, mortgage, or agreement of sale. An unlawful entry or detainer action. The filing or enforcement of a mechanic's lien. Any matter that is within the jurisdiction of a probate court. Further, the filing of a judicial action to enable the recording of a notice of pending action, le pendens, hopefully I pronounced right, or order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver of the obligation to submit the claim to ADR. Nor shall such action constitute a breach of the duty to mediate and arbitrate. All right, so attorney fees and costs. The prevailing party of any dispute or claim between buyer and seller arising out of relating to this contract shall be awarded their reasonable attorney fees and costs. Costs shall include, without mediation, attorney fees, expert witness fees, fees paid to investigators, and arbitration costs. If the seller and the buyer cannot agree on a reasonable award to the party that is not in breach, or they're asking for compensation from the party that is in breach, title is always going to go by the word of the written word of the contract. So whatever the contract says is how they're probably going to vote. And if that is still not okayed by the buyer and seller, then of course this is when you get into the arbitration. So just know that. And it does cost money. It's not free. All right, additional terms and conditions. So this is a section where you can write in things that will be made part of the contract. A couple examples is the buyer's agent is married to the lender. So in my case, if I'm representing a buyer and my husband, Bryson Erland with Starboard Financial is the lender, I have to disclose that. If I represent the seller and it's my sister, I have to put that in the contract. Seller's agent is related to the seller. Anything like that has to be disclosed. There is major fines for non-disclosure, especially when there's some kind of relation between the parties. Another item that you can put here is, let's say it's a flip and the seller does not have any seller disclosures and they are not going to be providing a clue. You can state here that the buyer is aware or acknowledges that no seller disclosures will be given and the clue will not be given. That is something that you can put here. Another item that you can put here is a clause. Such clause as, let's see, maybe the HOA document or addendum was not uploaded into the MLS prior to making the offer, so you don't know what those fees are. You can make your offer contingent on both parties agreeing to page 3 of the HOA addendum. And I have more verbiage on that, but that's just an example of what you could put here. All right, risk of loss. So if there's any loss or damage to the premises between the date of contract acceptance and close of escrow or possession, whichever is earlier, by life of fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be on the seller, provided, however, that if the cost of repairing such loss or damage would exceed 10% of the purchase price, either the seller or the buyer may elect to cancel the contract. So just know that if something major happens, if the loss is more than 10%, then the seller or the buyer can cancel the contract. If it's less than 10%, then the seller would be required to correct it. Permission. Buyer and seller grant brokers permission to advise the public of this contract. What that means is that we are able to put this data into the MLS. Once it's under contract, we update that so that we can advise the public that it is under contract. And when it closes, again, we are able to advise that to the public. This contract shall be governed by Arizona law, and jurisdiction is exclusively conferred to the state of Arizona. So just know that if somebody says, well, that's not how we did it in Washington, that's because we follow Arizona law. Time is of the essence. The parties acknowledge that the time is of the essence in the performance and obligations described herein. This is why their time frames are so important. We have certain time frames we have to stick with. If we don't stick with it, then our client is in breach. So when we tell our clients time is of the essence, that is what we mean. We never want to have our party, whatever we're representing, buyer or seller, in breach of a contract. Compensation. Seller and buyer acknowledge that the broker shall be compensated for services rendered as previously agreed by separate written agreements, which shall be delivered to broker to escrow company for payment at close of escrow. If not previously paid, if seller is obligated to pay broker, this contract shall constitute an irrevocable assignment of seller's proceeds to, at close of escrow. If buyer is obligated to pay the broker's payment, shall be collected from buyer as a condition of close of escrow. Broker compensation is not set by law, nor by any board, association of realtors, multiple service, listing service, or in any manner other than as fully negotiated between broker and client. And remember in part 1 of the residential purchase contract, on the first page of the residential purchase contract, I believe it's line 13 or line 38. Hold on. Sorry, yes, line 36. Nope, 37. Seller compensation has to be checked if you want the seller to pay your commission. And then the SCA has to be included. We'll go over that in another class though. Copies and counterparts. A fully executed facsimile or electronic copy of the contract shall be treated as an original contract. This contract and any other documents required by this contract may be executed by facsimile or other electronic means and any number of counterparts, which shall become effective upon delivery as provided for herein, except that the disclosure of information on lead-based paint and lead-based paint hazards may not be signed in counterpart. All counterparts shall be deemed to constitute one instrument, and each counterpart shall be deemed an original. So what does that mean? That means that a contract can be signed separately and then merged together, even though both parties have not signed that one form, the same form. However, a lead-based paint form, all signatures have to be on that one form, and that one form has to be passed around to each party and signed by each party. That's what counterpart means. In real estate, everything is done in days. All references of days in this contract shall be construed as calendar days, and a day shall begin at 12 a.m. and end at 11:59 p.m. So if my contract is accepted today, day 1 doesn't start until 12 a.m. So if today is the 19th of November, my contract, the first day of the contract is not until November 20th. So when you're calculating time periods, it's computing any time period prescribed or allowed in this contract, the day of the act or event from which the time period begins to run and is not included, and the last day of the time period is included. Contract acceptance occurs on the date that the signed contract or any incorporated counteroffer is delivered to and received by the appropriate broker. So that's your contract acceptance dates. So even though my time frame doesn't start until tomorrow, my contract acceptance date is still today, or in my example, November 19th. But my time period starts tomorrow, and I'll explain. Let's see. Acts that must be performed 3 days prior to close of escrow must be performed 3 full days prior. If close of escrow date is a Friday, the act must be performed by 11:59 on Monday. So that is stating that a day is a day is a day. So Saturday, Sunday, and Monday. Those are your 3 days. Okay. The entire agreement. This contract and any addenda and attachments shall constitute the entire agreement between seller and buyer, shall supersede any other written or oral agreements between seller and buyer, and can be modified only in writing signed by seller and buyer. The failure to initiate any page of this contract shall affect the validity of terms of this contract. Subsequent offers, the buyer acknowledges that seller has the right to accept it's a hard word to say, subsequent offers until close of escrow. Seller understands that any subsequent offers accepted by the seller must be a backup offer contingent on the cancellation of this contract. And please explain this to your sellers that they cannot do anything at all to sabotage this contract. Cancellation. A party who wishes to exercise the right of cancellation as allowed herein may cancel this contract by delivering notice stating the reason for cancellation to the other party or to escrow company. Cancellation shall become effective immediately upon delivery of the cancellation notice. Notice. Okay, we're almost done. Yay. Oops, sorry. Unless otherwise provided, delivery of all notices and documentation required as permitted hereunder shall be in writing and deemed delivered and received when either hand delivered, sent via facsimile transmission. Nobody sends faxes nowadays, but you can still do that. Send via electronic mail if email addresses are provided herein, or sent by recognized overnight courier service and addressed to buyer as indicated in section 8Q, to the seller as indicated in section 9A, and the escrow company indicated in section 3A. Okay. So this section 8-9 is kind of important, so let's go over that. Seller and buyer hereby expressly release, hold harmless, and indemnify brokers in the transaction from any and all liability and responsibility regarding financing, the condition, square footage, lot lines, boundaries, value, rent rolls, environmental problems, sanitation systems, roof, wood infestation, building codes, governmental regulations, insurance, price and terms of sale, return on investment, or any other matter relating to the value or condition of the premises. The parties understand and agree that broker do not provide advice on property as an investment and are not qualified to provide financial, legal, or tax advice regarding this real estate transaction. But who are they going to blame when something goes wrong in the contract? They're going to blame you. You are the expert. You are the pro. You are the realtor. So just reminds them that we are human, and if they have any questions, to make sure they ask the appropriate persons. I am not a attorney. I am not an accountant. That's why we don't give tax or tax or legal advice. You do not work for a roofing company. You are not an expert in roofing. Refer them to those individuals. And you know what? This section right here, I love this section because it states all of this. If you provide them with a buyer advisory notice, it covers a lot of things that buyers are worried about or buyers want to investigate, or, it gives them the ability to go to all these sites to do their own due diligence. So give them and have them sign acknowledging that you gave them a copy of their buyer advisory, and then make sure that you deliver to them after you've had them sign it a PDF copy of it so that they can go back and refer to it. And I always push my buyers to that document. It is a long document, but it's got hyperlinks and it is full of information. And I just feel like it gives you a little bit of another layer of protection because you've given them the tool for them to do their own due diligence. So, anyways, highly recommend the buyer advisory. It is not a required document, but I have every single one of my buyers sign it. And then I redeliver a PDF copy. Okay, so terms of acceptance. This offer will become a binding contract when acceptance is signed by seller and a signed copy delivered in person by mail, facsimile, or electronically and received by broker named in Section 8Q by X date and time, Mountain Standard Time. The buyer may withdraw this offer at any period prior to receipt of seller's signed acceptance. If no signed acceptance is received by this date and time, this offer shall be deemed withdrawn and the buyer's earnest money shall be returned. So you may be asking themselves, well, wait a minute, why would the buyer's earnest money be returned if we're not even under contract? Let's say the buyer was under contract on a different house. They ended up paying the earnest deposit. We ended up canceling, but instead of having their money refunded, they went ahead and held it at title. And this was the same title company. Maybe you just asked for that same title company, and that title company is still holding your earnest deposit. So that's kind of what that means. Rarely is a buyer ever going to prepay an earnest deposit before something's actually submitted. Title has to have a file or an address to attach it to, so. But it can happen. Let's see here. This is just stating that the contract contains 10 pages exclusive of any addenda and attachments. Please ensure that you have received and read all 10 pages of this offer as well as any addenda and attachments. Let's see this section and this section. This needs to be filled out, everybody. Don't leave it blank and send it over to the opposing team for them to have to do a counter offer or an addendum putting this information in. You can search for the agent in the MLS. If you just go to the MLS, search Tina Nerland where you would put in an address, it'll pop my name up and you'll be able to click on my broker. It'll give you ProSmart's information. It'll give you the agent's information. It should give you the email and the phone number, but that should be in the listing. So you really don't need it. And then just make sure you've got buyer checked here because you're representing the buyer. If you're representing like dual agency or, you're working with somebody within ProSmart, then you would check both buyer and seller. You don't necessarily have, you don't necessarily have to enter in this buyer address. You can if you know it, but you don't have to, just as long as the buyer's name is there. And then, of course, the broker's information from the seller. Depending on how you open the transaction, this information should be auto-populated. And I believe I already talked about that in a previous class, but we will cover it again. Or if you need additional training on that, just give me a call. Line 464 should be check seller, or again, if it's dual agency, you check both buyer and seller. And then if you're for some reason off sending over a counter, if you are the seller and you're countering a buyer's offer, you need to make sure that this is checked. And of course, seller signs every thing here. And then if by chance your seller is flat out rejecting a buyer's offer, you would just check here, put the date, and send this page over to the buyer's agent. And that is part 3 of the residential purchase contract. Again, I know it's kind of boring going line by line and reading it, but I can't tell you. I have read this contract so many times, and every single time I read it, I learn something new, or maybe I read it and I interpret it a different way. And so I'll ask broker Mike, hey, I read it a little different this time. Am I misinterpreting it, or can you help me understand it just a little bit better? So I highly recommend, even though you've just listened to this class or you've sat in it with me, to go back over it and read it over and over and over. Take notes, understand the timeline. You are the expert. Your clients are depending on you to know the contract inside and out. So do that. Learn it. Ask questions. If you need any clarification on anything, ask me. If I don't know the answer, I will get it from Broker Mike. And always, as a reminder, if you have a new contract, you have 10 days to open a file in Paperless Pipeline, and our broker has to review any and all signed documents by a buyer or seller within 10 days. So you have to make sure you are opening a file in Paperless Pipeline. There are fines and they can get hefty if you fail to do this. Give me a call if you have any questions. Thank you so much for attending. Have a great evening. I will talk to you later.